we're approaching a very exciting time in insolvency and restructuring, a so-called tipping point where the COVID-19 pandemic seems to be phasing out, hopefully, and businesses are starting to gain some traction. And with that positive momentum comes a lot of interesting issues concerning what's going to happen next. And so I thought a good starting point might be to distinguish between what I characterize as good companies and bad companies. And I think that a bad company, in my mind, is a company that is not profitable, successful, but for the fact that it's being propped up by government, either stimulus and or moratorium, which are preventing creditors from executing rights under various agreements. On the other hand, you have successful companies that are at the point in time where they're starting to transition in their business into becoming more active. They're developing cash flow or more cash flow and are financeable. So how do you distinguish between these companies? I think one thing that we do in the United States is we have a thing called a feasibility test, which is later on in the bankruptcy process, but I think it might work as early as the beginning of a stage of a workout, where you test the company's ability to function and to survive. And one of the things you might look at is what's the exit strategy? What is the company planning on doing to improve its business or to succeed? So I guess one of the questions I have is, should bad companies fail? And I think the answer is yes. I think bad companies should fail because there are many other entrepreneurial businesses out there that are looking for opportunities, and there's a lot of money that is waiting for opportunities to invest. And this is an opportunity where we sort of cleanse the market and begin a new process of bringing more and better run companies to the market.
Although the EU has, obviously the UK has exited the EU, we did actually start drafting up a set of proposals which would have aligned ourselves to the EU directive. And that included something called a restructuring plan, which is an updated version of a scheme of arrangement, which has been part of our law for some years. And the restructuring plan is a scheme of arrangement with teeth, in as much as it has an ability to cram down dissenting classes of creditor. And it can be any class of creditor. It could, in theory, be a lending secured creditor class that is crammed down. And that is brand new and is something that we've just not seen in our jurisdiction before. This sort of ability not only to put plans to creditors which are voted on, but if you have a dissenting class, to cram them down, which I think is something which is more akin to the US and something that you might have seen there. But this particular the tool is new for us. There has been 5 instances so far, and a very high profile one just over a week ago in Virgin Active, which is a chain of leisure and gyms, which has seen the landlord class, in this case, crammed down. It dissented, it didn't like the plan, which was going ahead, but despite its opposition, we saw the cram down. So there's quite a buzz in the industry at the moment that this might be the real breakthrough for corporate rescue, for company rescue, and something that might be really used as a tool with teeth in restructuring. And I think therefore there's quite a contrast at the moment as to our direction of travel.